Hi, following on from our last video, today we're going to talk about how do I go about bringing a claim under the Inheritance Act. One of the first things to do is to find out when the person died and also to establish whether a grant of probate has been extracted. The reason for that is that with this type of claim, you have a short period, 6 months from the date of the grant of probate in which to bring a claim. So it's best to just work out the position first.
The type of questions that we would ask if you came to us for a meeting would be, what was your relationship with the deceased? What was the deceased assets and the value of the deceased estate at the time they passed away? Were you provided for under the terms of the deceased's will? Had you been provided for financially during the deceased's lifetime? And lastly, what your financial position is like.
So what kind of evidence would you need to support your claim? What we're looking to do is demonstrate your financial position to the court. So we'll need to think about any properties that you own and whether they have mortgages on them, pay slips, information about pensions, are there any other investments or assets that you have? We would also take account of any debts that are owed to you or any financial obligations that you have to anybody else.
The reason that we ask for so much personal information so early on is that first and foremost the court will require this in their evaluation of your needs. In addition, the court would also conduct what's called essentially a balancing exercise in between weighing up your needs against any other competing beneficiaries whilst also taking into consideration the size of the estate.
So if you instructed us to pursue a claim for you, the way it would work is, first of all, we'd sit down with you and go through the evidence that you've got to establish whether or not you do have a claim. If you do have a claim, we would prepare what's called a detailed letter of claim, which basically sets out the basis of your claim and the evidence that you're relying upon. And once we have a response from the other side, we've got a much better idea of what we've got to deal with. We would usually try to explore with you trying to achieve an early settlement, either through telephone conversations, a without prejudice meeting, or mediation to try and resolve matters. If that's not possible, then the next step would be to issue proceedings. We also need to be mindful of the 6-month time limit that I talked about at the beginning. So if negotiations were ongoing, but that was close to expiring, what we would look to do is issue a protective claim to preserve your claim and then immediately stay it whilst negotiations carry on. Ultimately, with any kind of litigation or case, if a settlement can be achieved, generally that's better for everybody. It's quicker, it's cheaper, and you get certainty. But also the court does expect parties to behave reasonably, to exchange information freely in the early stages, and to try and resolve matters amicably. So if that doesn't work out, you will also be able to demonstrate to the court at a later stage that you have acted reasonably as well.
One of the most commonly asked questions is, how do I fund this, given that the reason that I would be intimating a claim would be because I haven't been provided for reasonably in line with the deceased estate. This is something that we can explore at the outset, so we can consider your financial position, and from that, once we have sufficient information, we can then look to discuss any alternative methods of funding, such as a conditional fee agreement with you. We hope that that provides a few helpful thoughts as to the next steps if you wish to bring a claim. If you do have any further questions or want to have a chat with either myself or Anna, please don't hesitate to contact us and look out for the next video.